Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Suppose you were a supporter of a candidate running for public office. In your enthusiasm, you posted campaign posters on the gate of your house. Can COMELEC take them away? What are the guidelines for regulating posting of campaign materials in private properties? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 6th of December 2024, and today we talk about the case of St. Anthony College of Roxas City et al. Versus COMELEC et al., decided on October 10, 2023. It's an en banc decision penned by Supreme Court Associate Justice Jose Maidas P. Marquez. And joining us to talk about this case is Supreme Court spokesperson, Attorney Camille Ting. Hi, Attorney Camille. Welcome back to the Supreme Court Podcast.
Hi, Attorney Mike. It's nice to be back.
All right. So let's talk about this St. Anthony College of Roxas case. Can you tell us what happened here?
So, St. Anthony's College and other private persons were owners of tarpaulins, posters, and other campaign materials expressing support and soliciting votes for former Vice President Leni Robredo. If you remember, she was a presidential candidate in the May 2022 national elections. So, these campaign materials were displayed on their private properties but were forcefully removed and destroyed by the COMELEC officers under Oplan Baklas, pursuant to COMELEC Resolution number 10730. This resolution gave COMELEC authority to remove non-compliant or oversized election materials.
Attorney Camille, when we say oversized election materials, what size are we talking about? What's the standard size for election campaign materials?
Well, under the said COMELEC resolution, posters must not be larger than 2 feet by 3 feet.
Right. So the election paraphernalia removed by the COMELEC were owned by the supporters, not by the candidate itself?
That's right. These election materials were owned by supporters of former VP Leni and not her or her political party.
All right. So in short, these are private posters posted on private property.
That's right.
Right. After the COMELEC removed the tarpaulins, what did the owners do?
So the owners, which is St. Anthony and several other petitioners, filed a petition for certiorari and prohibition with the Supreme Court and requested for a TRO or temporary restraining order. They argued that the COMELEC violated their rights to free speech, expression, and property through an unconstitutional interpretation and implementation of COMELEC Resolution number 10730 or the Oplan Baklas.
So they went straight to the Supreme Court.
Yes.
Was this allowed by the Supreme Court?
So the parties went directly to the Supreme Court due to the significant constitutional issues involved and the heightened protection afforded to political speech. The Supreme Court permitted this, exercising its full discretionary power to take cognizance and exercise jurisdiction over petitions for certiorari filed directly with it. It also noted that the petition fell within several exceptions to the doctrine of the hierarchy of courts. Furthermore, the actions of the COMELEC might create a chilling effect on the petitioner's right to political speech. In this case, the principle of exhausting administrative remedies was set aside to protect this fundamental right.
And did the Supreme Court grant the TRO?
Yes, the court granted the TRO.
And aside from granting the TRO, the court here ultimately granted the petition. Now, under the Constitution, the COMELEC is the body tasked to enforce all laws and regulations on the conduct of elections. In relation to this power, did the court discuss if the COMELEC can regulate election paraphernalia or propaganda? How about private speech?
So the Supreme Court ruled that RA 9006, also known as the Fair Election Act, only allows the COMELEC to regulate election propaganda that is owned by candidates and political parties. It does not grant COMELEC the authority to regulate the political speech of private individuals on private property.
So an example of the COMELEC's exercise of this power to regulate election materials is actually Oplan Baklas, which we're talking about here.
Yes.
Why did the tarpaulin owners claim the implementation of Oplan Baklas was invalid?
Well, they claimed that the implementation of Oplan Baklas was invalid because COMELEC had no basis to regulate their expression within their private property, as its power to regulate the posting of election propaganda applies only to political parties, party-list groups, and bona fide candidates.
And what were the COMELEC's arguments against this point, Attorney Camille?
COMELEC argued that the election materials are political advertisements or election propaganda as defined under COMELEC Resolution number 10730, hence they are subject to COMELEC's regulation. Moreover, the size limitation of election materials under the Omnibus Election Code does not distinguish between candidates and private individuals. Thus, they argue that these limitations are applicable to St. Anthony College and other private persons.
So, right. How did the court rule, though? Did it side with the petitioners, at least with their claim for their freedom of expression and claim of rights over their private properties?
The court ruled that the COMELEC's implementation of Oplan Backlash is unconstitutional, as it is not allowed by law and it goes beyond the limits of acceptable regulation set by the Fair Election Act and COMELEC Resolution number 10730. The court determined that there is no legal basis for enforcing this plan against private individuals regarding election materials displayed on private property. As a result, it constitutes an unlawful infringement on St. Anthony's right to freedom of speech and expression.
And what about the issue of violation of property rights? Did the court say anything on this?
Yes, so the court said that the COMELEC violated the property rights of St. Anthony as there was no legal basis for the COMELEC's entry into their private property and for the removal and destruction of their privately owned campaign materials.
Right, so at least that is clear now. COMELEC cannot just come in and take away those materials.
Yes.
Even if it claims that it violated the rules. So what's our main takeaway from this case, Attorney Camille?
Well, the main takeaway from this case is that COMELEC cannot regulate the political speech of private persons on private property.
All right, so thank you for this discussion, Attorney Camille. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for St. Anthony College of Roxas City et al. Versus COMELEC et al. GR number 258805, October 10, 2023. Here's Tiff Atendido Beltran, Supreme Court Information Officer for this week's Roundup.
At the Supreme Court this week. The Supreme Court reiterated that using online chat logs and videos as evidence does not violate the right to privacy if they are used to determine if a crime has been committed. The court upheld the conviction of a man for qualified trafficking in persons under Republic Act No. 9208 or the Anti-Trafficking of Persons Act of 2003, finding that the videos and recordings of the chat logs of his conversations with an undercover agent can be admitted as evidence. The court rejected the accused's arguments that they were inadmissible for violating his privacy rights. Republic Act No. 10173 or the Data Privacy Act of 2012 allows the processing of sensitive personal information to determine a person's criminal liability and to protect the rights and interests of persons in court proceedings. As the chat logs and videos were submitted as evidence to assess his criminal liability for qualified trafficking, his right to privacy was not violated. The court emphasized that the videos and chat logs were presented as evidence to show the accused's method of reaching out to foreigners through Skype or Facebook and offering minors for sexual exploitation. In another decision, the Supreme Court stressed that a person with an intellectual disability is not disqualified from testifying in court solely because of their disability. The Supreme Court emphasized that a person's ability to testify as a witness depends on their capacity to relay their knowledge. If their testimony is clear and understandable, it can be accepted. This is further reflected in AM number 1908-15-SC, which amends the revised rules on evidence to state that all persons who can perceive and perceiving can make known their perception to others may be witnesses. The SC also highlighted the importance of improving how people with disabilities are referred to. It advocated for the use of people first language, which emphasizes the individual before their disability. While the term mental retardate is a legitimate medical term, the court said it is no longer preferred because of its negative meanings. On December 4 to 5, the Philippine Judicial Academy, or PhilJA, conducted the National Judicial Colloquium on Intellectual Property Adjudication in the Philippines, in partnership with the World Intellectual Property Office and the Intellectual Property Office of the Philippines. The events brought together selected special commercial courts judges from the National Capital Region who applied what they learned from the customized distance learning course for judges on intellectual property law. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Victor Laranio and Don Ryan Balza as sound editors, and Tyke Flores and Jerome Batumalake as web editors.